Good afternoon or good morning, everyone, depending on where you are. And thank you for taking the time to join us today. I'm Tina Barr, the Director of Training and Education for the National Association for Civilian Oversight of Law Enforcement. NACOL is an organization that works to create a community of support for independent civilian oversight entities seeking to make their local law enforcement agencies, jails, and prisons more transparent, accountable, and responsive to the communities they serve. One part of that effort is our webinar series. Since 2015, NACOL has used the webinar series to bring you information on effective practices in civilian oversight, innovations in the field, and efforts to reform the criminal legal system. Before we get started with the webinar, I'd like to go over a few logistics. First, you have the ability to turn on the captions for this webinar by using the caption button at the bottom of your Zoom screen. Next, please know that everyone has entered the webinar in listen-only mode. The chat feature is disabled. However, the Q&A feature is on, and you may type your questions there at any time. Everyone will have the ability to upvote questions by clicking the thumbs up icon beside particular questions, which will help us to address some of the most pressing questions during the limited time we have today. To ensure that our speakers today cover all the information that they've prepared, they will respond to questions at the end of the presentation. To allow more time for direct engagement and answers to questions between the speakers and yourselves, immediately after the webinar, we will have a 30-minute discussion. This discussion will take place in a Zoom meeting room, which is separate from this Zoom webinar room, which means at the end of the webinar, you will have to log off of this webinar and then log on to the Zoom meeting room. About 10 to 15 minutes before the end of this webinar, I will share the Zoom link in the one-way chat for you, as well as in the Q&A feature so that you can have it. And you'll be able to either cut and paste that link or you can click it directly. Please note, however, that once you click the link, if you click it in from the chat or the Q&A feature, that you will log off of this webinar and go directly to the Zoom room. Finally, today's webinar is being recorded and it will be available to registrants for the next 3 months. In about 5 business days, you will receive an email with information on how to access the recording, as well as a PDF version of the slides that are being used today. So without further ado, let me go on to the webinar. For the sake of time, I'll give an abbreviated description of the webinar and abbreviated bio for our moderator today, who is Jerry Threet. Please know that the full webinar description and Jerry's full bio, as well as the bios for our panelists today, are linked on the webinar page of the NACOL website. Today's webinar is titled Hate Crimes, Explicit Bias, and Implicit Bias, Evolution of Standards for Decertification of Peace Officers in California. The webinar will explore how recent laws in California are changing employment standards for what personal actions and/or beliefs are acceptable for peace officers to hold or express and still be hired or continue as employees of law enforcement agencies in California. Panelists will examine recently enacted laws, each of which may bear on these issues. Our moderator today is Jerry Threet. Jerry is an attorney and consultant in private practice following a long, varied legal career in government service. His practice focuses on police practice, oversight and accountability, public records and transparency, and public employment. So without further ado, I will turn things over to you, Jerry.
Thank you, Tina, for that introduction. And good afternoon, everyone. Mostly afternoon for most of us, and good evening, Demetra. Thank you all for joining us for what we hope will be a helpful and interesting webinar about the issue of bias by peace officers and how California approaches this issue. I want to say most of our focus in the webinar will be on 4 California statutes that apply to this issue, but I also hope you will keep in mind the agency policies that may apply also in your jurisdiction and consider how consistent they are with these statutory provisions. Okay. I'm going to be facilitating our discussion after a short presentation to get us started. And I'm very happy to welcome an outstanding panel of experts who I'll introduce in the order of their presentations. While the introductions will be brief, as Tina mentioned, there are links to their full bios on the registration page for this webinar, and I hope that you will go and check them out because they're very impressive. So turning to our first panelist, John Alden is currently the Department Head and Inspector General of Sonoma County's Independent Office of Law Enforcement Review and Outreach, or ILRO as most people call it. John formerly served as a DA in Sonoma, Marin, and San Francisco counties, and he has over 15 years experience specifically in the field of civilian oversight in various capacities and currently serves as a member of the board of NACOL. Ed Obayashi is a special deputy and policy advisor for the Modoc County Sheriff's Office. He also concurrently serves as the chief investigator of that county's district attorney's office. Despite that already impressive work portfolio, Ed also is a top trainer for law enforcement in California, particularly in the areas of use of force and bias. Ed also serves as an expert litigation consultant in cases involving police officers. Finally, Demetra Smith is the program manager for the Sonoma County Black Therapy Fund, a first of its kind service for the Black community of that county. She is also the former chair of the Sonoma County Human Rights Commission, where I had the privilege of serving with her. Demetra also is the originator and co-author of the CLEAR Act, one of the laws we will be discussing today. So, let's see. Without further ado, we'll just dive into our webinar. I'm going to give you a brief overview of what we'll be covering today and then move into the first section. I'm going to start by covering key provisions of the decertification law passed in California in 2021, which provides one framework for our discussion. John will then cover provisions of the Racial Identity and Profiling Act, or RIPA, and how it may be related to other statutes we will be discussing. Ed will then inform us about provisions of the Racial Justice Act, which is significant in its own right, and then we may touch on how it interacts with these other statutes. Demetra will then tell us about the CLEAR Act, including its unique features and how it may interact with the other statutes. And finally, we're going to end with some discussion on the implication of these laws, including on the employment of peace officers. So the Decertification Act. Senator Bradford's Decertification Act was enacted in 2021. It provided for the first time in California a process for decertification of peace officers found after investigation to have committed, quote, serious misconduct. That term, serious misconduct, is defined under the statute and may include unreasonable force, lying, and other misconduct, including for our purpose here, quote, demonstrating bias, end quote. While much of the discussion of officer misconduct understandably focuses on use of force, bias is in many ways an equally or more important issue for our consideration as oversight professionals. As we know, bias pervades our culture and thus can affect officers' actions interacting with the community, whether conscious or not. The statute delegated further definition of the term demonstrating bias to California's Commission on Peace Officer Standards and Training, or POST, as it is known. POST provided further guidance consistent with the statute, focusing on an officer's words, actions, or conduct that may display prejudice, intolerance, contempt, or hatred toward a person or class of persons who are protected by law. Notably, the definition uses the, quote, reasonable person, end quote, standard to consider whether the words or conduct of an officer indicates that they could fairly and partially perform their duties. Given this framework, one question to keep in mind as we explore the other laws that will be discussed today is whether those other laws' provisions would also constitute, quote, demonstrating bias under the Decertification Act. The import of that may be that those other provisions, if violated, might also result in decertification of an officer. So with that framework and that introduction, I'd like to turn it over to John Alden, who will take us through the Racial Identity Profiling Act.
Thanks, Jerry. I appreciate the intro. I'm going to assume that a lot of people here are not from California, and you probably haven't heard a lot about the history of RIPA, the Racial Identity Profiling Act. So I'll hit a little bit of that first. This particular piece of legislation was passed in 2015. And at that time, if you think back there 10 years ago, there was a lot of concern in community in California about racial profiling by police officers throughout the state. There was at the same time substantial pushback on that issue from many in law enforcement, claiming that racial profiling simply wasn't happening. And so part of the debate in 2015 and the years prior was not, as we might be discussing today in a lot of places, how to end racial profiling, but even at that time, whether racial profiling was happening. And so there were a number of jurisdictions prior to 2015 here in California that had started trying to track exactly who was being stopped by their local law enforcement agencies. And as a result of that, it started becoming clear that at a minimum, the population of people who were being stopped by police officers in traffic stops was quite disproportionate by race as compared to the rest of the population in California. San Francisco is one of the leading jurisdictions that started that work, along with some others. And the fact that that data was beginning to show that there was such a thing as at least racially disproportionate effects in traffic stops, if not outright implicit bias, explicit bias, or racial profiling, really got the ball rolling, such that by 2015, when the legislature was debating whether to create this particular act, there was starting to be substantial conversation in California about how to at least prove that the ways in which police officers were stopping people, whether for traffic stops or other kinds of law enforcement stops, really was having a racially disproportionate effect on community. When this bill came forward in 2015, the concept behind it was to measure exactly who it was that law enforcement believed they were stopping in traffic stops and other kinds of enforcement actions. That by itself was a controversial concept, despite some of the data from San Francisco and other places showing that disproportionate effect. Law enforcement still strongly opposed this particular bill. When it was moved forward in 2015, in fact, it had to gain at least 40 votes in the state assembly. That's a body of 80 legislators. At the time, there were more than 50 members of that body that were Democrats, but nonetheless, the bill still only got 43 votes, just a little bit more than necessary to pass. So I think it's helpful, again, to put ourselves back in the pre-George Floyd mindset of 2015 and recognize this was a really groundbreaking concept at the time. The RIPA bill, AB 953, had, from my perspective, 4 important parts. One was that it explicitly bans racial profiling by police officers. That's significant for a number of reasons. One was that at least here in California, we didn't have any explicit ban on using race as a factor in making a traffic stop or enforcement decision anywhere in California law. Now, that's not to say there was any California law saying one could, but there was not a California law that said one could not. As a result of RIPA, we now have a rule in California that says that that's a prohibited practice, with the caveat that RIPA did not create any kind of enforcement mechanism for that. So once RIPA passed, there was no civil remedy for an officer who might engage in racial profiling, at least not directly under RIPA. And there was not any criminal penalty. So it really was up to local law enforcement agencies to create internal rules banning racial profiling and then enforce those through internal affairs investigations or civilian oversight investigations of their own members. Nonetheless, that law creates a foundation for that kind of responsibility. And because this particular piece of legislation, RIPA, was the first in the ones that we're going to talk about today, it creates some foundation for the other pieces of legislation that you're going to hear about in our presentation. It's also important to remember that because RIPA was the first in this set, it didn't make any reference to the others. They didn't exist yet. And it's not always clear exactly how they work together. So I'll talk a little bit about how maybe some of these statutory schemes do and do not coexist or function together. A second item that RIPA created in addition to that ban on profiling was a process, a requirement for tracking this data across all law enforcement agencies. It created an obligation on behalf of those law enforcement agencies to start tracking this data and rolled it out slowly over time such that the largest agencies in California were going to be required to track this data first and the smaller agencies later. Today in 2025, I believe every agency in California is now required to track this data. And so as you look back from the time that this was implemented in 2015 to today, the body of data we have every year has gotten larger and larger and larger across the state. The third thing that the RIPA did was to create a public board with appointees from a variety of different backgrounds, some of them from law enforcement groups, some of them from government, some of them from the public, who are responsible for making recommendations to how this data would be collected and tracked over time, to also assess and study the data so that the public could understand what the data shows, and to recommend ways in which training or other policy changes could happen across agencies in California to help ameliorate or eliminate racial profiling. And finally, the last thing that this legislation did was create an obligation that all law enforcement officers in California be trained on some core principles around the history of race in policing and the importance of not using racial profiling and the ways in which discrimination can show up in the criminal justice system. The Commission on Peace Officer Standards and Training, which is ultimately run by the California Department of Justice, and another board there is responsible for rolling out that training. And this RIPA board provides suggestions about what that training might look like. Today, officers are required to repeat that training every 5 years. So shortly after this process of collecting data became law in California in 2020, for example, we started seeing some data rolling in from larger agencies through today, 2025. We've seen some consistent patterns in that data. One is that across the board, in virtually every jurisdiction in California, the proportion of people stopped by law enforcement, whether for traffic stops or arrests or detentions, is quite disproportionate to the population. Depending on the jurisdiction, African Americans are stopped at 2 to 4 times the rate of other people in the population. Latinos, likewise, 2 to 3 times as often as other people in the population. Asian Americans are stopped at a rate vastly lower than all other categories. In addition to that, there are other ways in which the data shows disproportionate stops. One is that 70% of people stopped in most years in California across the board are male. In addition to that, when you look at certain more specific groups, you see disturbing trends too. For example, if we look just at minors who are stopped, people who are under the age of 18, more than 50% of them are Latinx. Across the state, which is a pretty stunning number when you think about it. The RIPA data also tries to capture today how complaints about racial profiling are collected at the local level and how they're resolved. In the most recent report from the RIPA board in 2025, they categorize exactly what they're seeing in that data, and they were able to show that only 0.32% of all complaints about racial profiling actually were sustained or found to be true, that an officer did engage in racial profiling. So that is 1/3 of 1% of all of the complaints in the state sustained. It's a remarkably low sustained rate, and I think that's going to lead to some questions with some of the other statutory schemes we're talking about. Like, for example, how does one prove racial profiling in these cases? If that rate is that low, it does call into question whether we're actually effectively able to investigate those cases. Now, I think that there are some positives that have come out of this tracking. One is, as I mentioned earlier, it's really resolved the debate publicly about whether traffic stops and other kinds of detentions or arrests have had disproportionate effects on the African American and the Latino communities. Now that we have a solid 5 years of data showing a consistent and dramatic disproportionality across the entire state and in virtually every agency in California, I think there's really no argument now that those law enforcement actions are landing disproportionately on people of color. 10 years ago, when RIPA was first implemented, I think the public conversation was whether there was disproportionate effect. So that is a dramatic, I think, sea change. One way in which we've seen pushback to that sea change in public understanding about our criminal justice system is that folks in law enforcement sometimes will say, well, a challenge with RIPA is that it asks for an officer, when they make a stop, to draw their own personal conclusion about the racial background or sexual orientation of the person that they're stopping, or even the gender of the person they're stopping, and then to enter that into the RIPA database for that stop, without necessarily relying on, say, a driver's license or asking the person what their particular background is. Some folks in law enforcement therefore contend that the data captured by RIPA is too subjective to be a reliable measure of who is actually being stopped. From my perspective, I think collecting the data that reflects the subjective understanding of the officers making the stop is actually critically important, because if the overall purpose of RIPA is to be a check against racial profiling or a check against bias, then what we're trying to assess is, who does the officer think they're stopping? What is the subjective understanding of the officer at the time they're making the enforcement decision? Do they think they're stopping someone that's Black? Do they think they're stopping someone who's Latino? Do they think they're stopping someone who's white? And then from there, we want to capture that understanding, because that subjective intent, that subjective perspective, is essential in tracking whether or not there's explicit bias that's causing these stops, or implicit bias that's tracking these stops. Now, I will say that I think a challenge that we have with this data is it is very difficult to distinguish in this data whether these disproportionate stops are caused by explicit bias, whether they're stopped by widespread implicit bias in the population of law enforcement officers, or are they the result of the impact of enforcement decisions that we've made here in California? I'll give you an example. Back in the 1990s, the state of California became much more aggressive about sanctioning unlicensed drivers and drivers with suspended licenses or suspended driving privileges. And what we figured out within a few years of implementing that fairly aggressive enforcement scheme was that vastly disproportionately the number of people who were in that situation of being unlicensed or driving on a suspended license were people who could not get a license because they didn't have legal status here in the United States. And at the time, California would not issue them a driver's license if that were the case. So we ended up effectively penalizing people who were in the state without federal authorization for their immigration into the United States. And we were not actually capturing people who were scapegoats or intransigents about being licensed and maintaining a valid license. So we inadvertently ended up criminalizing a whole set of people who had no way of complying with that obligation to have a license. As a result of that, we changed our mechanisms here in California and did start issuing driver's licenses to people regardless of immigration status. But for some time, we had a very disproportionate number of people in our criminal justice system solely because they were not in the country lawfully in the first place through the immigration system. So we may be having some similar effects here in what we see in the RIPA data. And for those of us that continue to work on that data and for the RIPA board, distinguishing those three categories, explicit bias, implicit bias, and bias in the effect of an enforcement decision is something we're gonna have to keep unpacking. There are many more observations we could make about the data in this set. It's remarkably valuable. And I'd encourage any of you to go take a look at the website for the RIPA board. Their original report back in 2018 was about 50 pages long. The most recent report was 200 pages long, and the recommendations there are just fascinating. I think we're going to see a lot more work on this data set over time, and that data set's probably going to improve and become more robust over time, I think, as we continue the process. I know that we have other statutory schemes we're going to talk about here in a minute. So I'm going to hit this last slide here that Jerry just put up and then go to our next presenter. I think that one factor I might use as a segue is I have been asked a number of times, can one use RIPA data to show that an individual officer is intentionally engaged in racial profiling or has a consistent bias that an agency should take action about, like say by taking discipline against them or retraining them or even decertifying them. I think that's really hard to do with the RIPA data because it's capturing, yes, it is. I mean, it's capturing data about stops over a period of time, and you could at any individual agency delve down into that data and see who an individual officer is stopping on a regular basis if you at the local level want to keep that data. That said, I think it's challenging to separate that data out from, say, who is the population that that officer has been asked to do enforcement actions against. You know, there are still in California some deeply segregated parts of town and most of our communities. And if one is asked to do traffic enforcement in one part of town as opposed to another, the population of people you stop might be quite different. And I don't know that we have figured out a good way to separate out that data yet. So that's a limitation of the data, perhaps.
John, a couple of questions before we move on. One is that I notice in the RIPA bias prohibition, it uses broad language such as it prohibits profiling or the reliance on race to any, quote, any degree. And in your experience, do police agencies and civilian oversight agencies, for that matter, who do investigations, tend to analyze this issue in complaint investigations using such a broad lens, or do they tend to require evidence of direct bias to sustain a finding of racial profiling?
In my experience, they tend to require evidence of direct bias. And I think part of that's because on the rare occasions that we have some direct evidence of explicit bias, like say a racist comment by a police officer, those cases are just vastly clearer. And in addition to that, I think we still struggle at the administrative level to figure out what evidence of use of race would be acceptable and would be sufficient to prove a case. In addition to that, the policies from agency to agency about what that broad language means for them at a local level can be quite different. So for example, I used to work with an agency here in Northern California that had a rule that racial profiling would only be disciplinable if the officer had no other legal basis for the stop other than race. Race is, of course, not a valid reason for a stop, but basically the agency would have to prove that the officer had engaged in the stop for no lawful reason whatsoever, and that it was motivated by race. That's a really high standard. There are other agencies that have lower standards, ones where simply using race for any purpose is prohibited. But what exactly that conduct would look like or what exactly the proof would be, I don't think is very clear. And that's part of why we see in the RIPA data from 2025, this 1/3 of 1% sustained rate on claims like that.
Yeah. And I might suggest that this might be a fruitful area for oversight agencies who work on policy matters to further develop recommendations for how to prove these issues. So assuming that you have a case where the facts show that there is racial profiling under the RIPA definition, in your opinion, would that also meet the standards for demonstrating bias under the Decertification Act?
I think it would. I am not aware of anyone who's actually done that yet. But in that regard, I do think they're a fit.
Yeah. Okay, thank you. And now I'm going to turn it over to Ed Obayashi, who's going to take us through the Racial Justice Act. Thank you, Ed.
Thanks, Jerry. First of all, please keep in mind, I am, as Jerry introduced me, I am a sworn peace officer in California, but I don't speak on behalf of any group, department, in this matter. What I have to pass on to the audience is really based on my experience in dealing with these issues for longer than I can imagine. I started out when, prior to RIPA, as a result of a consent decree between the state of California and the California Highway Patrol, we were mandated to collect RIPA data similar to the current standards way back then. Like I said, this was in the 1990s. So it wasn't the first attempt at trying to collect this type of data. And then secondly, regarding bias, that's an area where most of my career has taken me into deeper and deeper depths over the past few years. Prior to, let me put it this way. Years ago, matter of fact, the LA Times ran an article on this matter, where I, not to self-advertise or anything, but I told the LA Times there was no way you can prove an officer is biased or has demonstrated racial animus. There's absolutely no way. Up until about maybe, I think, 15 years ago, I think it was about 15 years ago, the first and only case where an officer was found to have violated department policy by conducting stops based solely on race was an LAPD officer who was purposely filling out these RIPA cards. I'll call it a RIPA card, or not the RIPA card, but the citations, and was actually purposely lying about the race to show that he wasn't stopping minorities on a disproportionate basis. That was the only case that was ever sustained, and this was after decades and decades of police history, which was pretty astounding. But I said, from a investigative standpoint, it's not surprising, because the only way you're going to prove that an officer was biased if he gets up on the stand and says, yes, I stopped that motorist only because of his or her color. And what cop is going to do that, right? But let's fast forward to 2018, late 2017. Anyway, I started getting complaints from departments asking me to look into the internet activities of officers. And that's where bias, my statement saying you can never prove bias unless an officer gets up on the stand and admits it, that blew my long-held belief out the door. Because now officers, and this is not just California folks, because I've talked to and done lectures out of state. I don't get it. I just don't understand it. And I gave this presentation to panel of chiefs about 2 weeks ago, and I'm afraid our biggest enemy, I'm talking about law enforcement, isn't I say image problem. It's not use of force. It's not dishonesty. It's none of those. Those happen, or commit crimes. Like officers got involved in a burglary, or they're committing embezzlement. That comes with just natural. After almost 100,000 officers in California, you're going to have rogue officers. What is much more serious threat to law enforcement, as I told the chiefs, is that I'm afraid officers on a very wide scale in California and the country have become radicalized. And they're proving it because of their internet activity. I have the only social media misconduct course in California, certified by Post. And use of force has always been my bread and butter. But in terms of training requests, social media misconduct has jumped to the forefront. I have departments shutting down for a full day so that they can run their officers and civilian staff through this social media misconduct course. Unless you've been living under a rock as oversight, and I don't mean to insult anybody here, you know what I'm talking about. Take, for example, the Antioch fiasco. Since when do officers think it's okay to text each other on duty, telling each other and whoever else may want to listen that it's okay to beat up Black people, and using the N-word explicitly, saying, I hate these Blacks. Let's find a better way to make them, to hurt them. And I use that because the RJA Act was brought into operation by the defense attorneys for some of the defendants that were arrested by Antioch PD recently. For four defendants of color, they were charged with murder, attempted murder, and a variety of other felonies. As a result of this explicit bias demonstrated by the Antioch officers, their charges were reduced to manslaughter and some other minor charges. That's the effect of the Racial Justice Act. I don't want to go through and read it word for word, but basically the Racial Justice Act holds that if the defense can prove by a preponderance of evidence, just 50+1, that there is some evidence that the officer demonstrated bias in his or her stop or arrest, then that can proceed to the next phase of discovery, in terms of, and that dovetails into what John was discussing, compiling statistics, utilizing statistics for the purpose of showing that, yes, the arrests or stops were motivated by bias. Now, the RJA was enacted in direct I don't want to say attack, but it was to counter the U.S. Supreme Court case. I can't remember the name, but Kemp versus McCleskey, I believe, 1987, where the court held that the use of statistical data to show that Blacks were disproportionately being executed could not be used as a factor for the defense to show that races are different minorities are being executed at a much higher rate as compared to whites. Therefore, it's inappropriate judgment. The Supreme Court said, no, we're not going down that road. But the Racial Justice Act was enacted to counter that. So I want to talk about implicit bias, and that was discussed by John earlier. There are very few, these explicit bias incidents are across the board in California, all the way from the smallest agencies all the way to the largest. I can't tell you, I can't keep up with. I've got more than enough lifetimes of work to do on this. The officers are being investigated. They're being disciplined. I could tell you this right now, for those of you who may not be aware of this as oversight committee members, the #1 leading cause of terminations in California law enforcement is not use of force. Matter of fact, that's very rare that an officer would be fired for use of force. It's not for dishonesty. It's not typically for, criminal acts like DUI or domestic violence. It is demonstrated bias on the internet. That is the number one cause of terminations. And with an officer uses a racial slur, advocates violence against protected class, which they are doing. You can just go on the internet and find these cases. They're automatically going to be terminated by the department. So even if the department addresses the issue somehow, and I can't think of hardly any that don't just summarily terminate the officer for this kind of misconduct, then SB2 is going to get involved. But that's much further down the line. And SB2, the Commission on Posts for SB2, will decertify them. So there's I hate to use the term backstop, but that's the backstop. Now you're not going to, it's going to be, and as a law enforcement investigator, I don't want to go down that road either. Because if an officer stopped an individual because of implicit bias or otherwise unintentional bias, I am not going to fault that officer. We all have implicit biases. I've got them. I've experienced it in my career numerous times. Was it intentional? Of course not. But we all do have those biases. And if we were able to even prove such bias to begin with, it's not going to fall nowhere. It's going to fall under the malicious category, serious misconduct, because it's unintentional. We try to deal with it, address it as much as we can, control it, but that's all we can realistically ask any officer to do. So just be aware that we all have implicit biases. I've been training officers on racial bias training for decades as well, and that's all we can ask is, just be aware of your implicit biases and think about them because they do exist. And hopefully, self-reflection, improves policing in that area. And to follow it up, there is a bill in the California Senate right now that is pushing its way through, and it's got pretty much unanimous support, where to follow up on what I just talked about, the legislature is not going to punish officers if they have been found to be in violation of the Racial Justice Act, because that would be problematic, impossible to prove. If the officer it was demonstrated in court that yes, the officer demonstrated perhaps the stop was motivated by implicit bias. No, the legislature doesn't want to punish those officers. That's just not the way California society wants us to, police the police, so to speak. There is one case I wanted to discuss dealing with implicit bias, and it's the Bonds versus the city of San Diego, where an officer stopped a vehicle and basically did a U-turn, traffic stop, no drama at all. Everybody was polite, and the officer, and it's not in the case for some reason. I'm going to assume it was a legitimate stop based on some type of traffic violation, but the facts in the case don't talk about that. Otherwise, it'd be suppression motioned out. But the officer recognized the occupants, the driver and the passenger, said, "Hey, I stopped you guys before." And the driver said, "Hey, why'd you stop us? Was it because basically our hoodies and so forth?" "Yeah, and also the area where I'm patrolling right now." Yeah. The court determined, but didn't. I'm talking about the trial court, did not talk about implicit bias whatsoever. But let's see, the individuals were convicted. This went to the appellate court. The appellate court said, no, the Racial Justice Act does address implicit bias. Implicit bias is a factor that the courts must consider in determining whether or not the stop violated the Racial Justice Act. So implicit that we have the very first case, and it's a very good case in terms of the bringing an RGA motion, Bonds versus San Diego. But I will tell you, the original trial judge of that case expressed open hostility against the RJA. I understand other judges have too. As a result, the trial judge in the Bonds case was later sanctioned by the Judicial Council for his comments in open court about the Racial Justice Act. So it's still a work in progress, folks.
And can I follow up with a couple of questions for you?
Sure. Mm-hmm.
I think you covered one of them, which is you referred to the RIPA data. And as you mentioned in the Bonds case, that was part of what was presented by the defense counsel to seek further discovery. And apparently that RIPA data can be useful in that process. Is that correct?
Yes, it can be, but it is expensive, as you can imagine, getting statistical data and then hiring experts or
Yes.
an expert to interpret the data, so forth. So, but it's a long, drawn out process. I've been asked to testify in court as an expert on interpreting the data on explicit bias, implicit bias impact. It's very complicated, as you can imagine.
Yes. And you did mention that there is a law pending in the legislature that would look at these cases and say the fact that a judge found on the record that there was some bias by the officer does not mean that that constitutes demonstrated bias under the Decertification Act.
Like explicit bias as opposed to implicit bias.
Yeah, and it looks like that law is close to passage and may pass. So I guess my question is, if that law is in fact enacted, if someone filed a complaint or a complaint investigation was opened about that officer's behavior, would they would still be able to look at that same evidence considered by the judge and make their own determination about whether it constituted bias?
That's correct, but there's also going to be a separate internal investigation. No competent internal investigation is going to rely solely on a court's decision, or a case, because as you can imagine, evidence that is otherwise inadmissible in a court of law is always admissible in these internal investigations.
Yeah.
So it's a clearer path to finding out what really happened.
Okay. And then I'm interested in the issue of the Brady list issue. So if a court did make a finding on the record that this officer's conduct constituted some form of bias, and therefore we're either throwing this case out or reducing the sentence or whatever the consequence may be, does that have implications for whether this officer needs to be put on a Brady list and disclosed to defense counsel in the future?
Not necessarily. The respective DAs, will have to make that decision. But again, there's going to be a lot of nuances, so to speak. The judge may determine that yes, this because the judge does not make a determination whether to place an officer on a Brady list. He's just there. Yeah. He or she is just there to determine, okay, was there bias in this situation? And there can be all sorts of levels of bias. So again, the Brady list issue is going to be a separate matter. The department is going to look at the underlying conduct to see if that was violative of the law and violative of policy. Not necessarily a violation of the RJA, different factors. So if the officer gets up and says, oh yeah, I stopped that individual because I just felt like stopping a black today, and that's a slam dunk. Okay, you're going on the Brady list and also you're getting terminated.
Okay, thank you very much, Ed. Appreciate it. And now we're going to turn to the CLEAR Act, the California Law Enforcement Accountability Reform Act. And thank you, Demetra. Take it away.
Thank you, Jerry. Appreciate it. So before I talk about this, I'm just going to say that as a Black woman and a human rights advocate and an activist, I come from a demographic and a community that has experienced racial profiling and bias and harm from law enforcement, and have also tried to represent communities of color who are very familiar with these problems, these generational problems. And, you know, those of us in communities that are deeply affected by this can say that policing in and of itself is rooted in bias as an outgrowth of the history and legacy of slavery and genocide and displacement of Native Americans in this country. So the idea of the debate of these things existing, you know, for communities that are really impacted by it is it's like a non-starter. We live in a country of laws, we hope, where these things need to be debated and codified and policy needs to be created. And I'm a person that doesn't have, you know, the decades of experience with policy. I came to this as a person, as a human rights advocate, seeing a lack of protection for a very serious problem that was outlined by the FBI. So I'm going to just talk a little bit about that history and why I felt it was necessary to push for state legislation. I began working on the CLEAR Act in 2017. I became familiar with the 2006 assessment report from the FBI, Counterterrorism Division, White Supremacist Infiltration of Law Enforcement. So despite this very urgent report by the FBI, there had been no concrete state or federal legislative action taken to address this problem, which was at least 20 years at that time documented of infiltration of law enforcement by hate groups, which was clearly defined as a national security concern, domestic terrorism being the top national security concern. Many of these elements within existing law enforcement agencies have utilized identifiers and behaviors consistent with those of organized street gangs, including displayed white nationalist insignia, tattoos, gang names, etc. Some of these factions are identified in the 2006 FBI report as ghost skins, which are active members of or individuals associated and affiliated with white supremacist groups who wish to remain unknown. So the report states that leaders and groups have historically shown an interest in infiltrating law enforcement communities or recruiting law enforcement personnel. Since 1991, numerous cases have also shown links within law enforcement to hate and militia groups such as the Ku Klux Klan, the Oath Keepers, Three Percenters, Identity Europa, Proud Boys, Blood and Honor, and so forth. These elements have also been found in Border Patrol law enforcement ranks, which of course are not covered by the CLEAR Act. So I became aware of this report and I was just shocked that nothing was being done about it. And then in 2017, former Trump administration Attorney General Jeff Sessions immediately worked to limit the scope of the Justice Department's Civil Rights Division, dismissing efforts to seek justice for people killed during police encounters, ensuring the Justice Department did not pursue federal civil rights charges against the officers involved in the deaths of folks like Alton Sterling and Eric Garner, et cetera. And under previous attorney generals, the Justice Department had launched civil rights investigations into local police departments and implemented consent decrees in an attempt to end racially discriminatory police practices in many places throughout the country. But with AG Sessions, this systemic police reform in partnership with the federal government was abruptly ended. And then before he resigned, Sessions also instructed signed a memo making it harder for the Justice Department to enter into consent decrees with police departments accused of civil rights and liberties abuses. So we have the problem as defined by the FBI. The FBI is stating it's a problem nationwide. We now have the federal government rolling back any oversight, and one can only assume that leadership of these agencies in which these groups exist are either unaware or they are harboring or looking the other way. And that I couldn't find another reason why this would continue to be a problem, because we have hate crime statutes, we have penal codes, we have all of these laws that are supposed to protect us from this kind of domestic terror activity and these kinds of hate crimes, and yet the problem continued to grow. So from my standpoint in 2017, at that point, this racially coded rhetoric of the Trump administration combined with this rolling back of civil rights protections and federal oversight of law enforcement was deliberate messaging that emboldened domestic terror elements. And since some of those are included in law enforcement agencies, according to the FBI, it to me seemed to be an extremely huge public safety threat that really needed to be addressed. I feel that it's still just as urgent today, if not more so. In my opinion, there have been former members of various hate groups who have testified, before Senate committee hearings that in the 80s, a concerted effort was made to kind of move away from the visible street marches and neo-Nazi and Klan regalia and things like that, and to actively seek military training, elected office, and positions within law enforcement in which an officer has access to weapons and qualified immunity. And so it's a perfect place for these kinds of elements to operate. There's also been many cases of these kinds of folks also targeting other police officers, Black police officers within their agencies, or elected officials, school district trustees, things like that. So basically, again, with the current Trump administration's attacks on civil rights, immigrants, people of color, the undocumented, LGBTQ+ populations, et cetera, political opponents, and then the public alignment with things like the Great Replacement Theory and establishment of white Christian homelands, and all of these things that are kind of aligning themselves with white supremacist ideology. This again is messaging that is continuing that really erodes public safety. And again, nothing had really been done about it. So in early 2017, numerous county sheriffs, many with alleged ties to domestic terror or militia groups, met with Sessions and Trump in DC to pledge their support for these policies. And again, this public expression of alignment with the administration that was actively rolling back civil rights protections was a major concern. And one of those sheriffs was from Sonoma County, whose deputies had been implicated in violent and costly civil rights violations and use of force cases. And so, and Sonoma County in particular, as far as issues with law enforcement, use of force and civil rights violations, had already been cited by the United States Civil Rights Commission in 2000, in addition to long-standing concerns from local communities of color that militia and white supremacists were likely embedded within various Sonoma County law enforcement agencies. And so as the vice chair of the Sonoma County Commission on Human Rights at that time, I felt compelled to act. And so I wanted to seek statewide legislation to ensure that California would be the first in the nation to mandate screening to root out extremists embedded within law enforcement agencies, leading the way for other states to follow suit. So again, we're not talking about whether there's bias or not. We're talking about something that is way more intentional, way more calculated, and that follows a pattern that has been documented, not only by the FBI, but has been shown to be a huge problem in many states. And so we worked with, I looked outside of Sonoma County so that we could, try to create a statewide legislative pathway. I found partnership with Dr. William Armelin, PhD, and Edith Kinney, PhD at the San Jose State University Human Rights Institute. And we worked to develop the legislation and find a state representative who would really champion the bill. And so we consulted with several folks who have contributed greatly to this work over the years in investigative and legal capacities, and who have also testified before Senate committee hearings on this issue. And those include Samuel V. Jones, whose 2015 work, Law Enforcement and White Power, an FBI Report Unraveled, really brought the 2006 FBI report back into the public discourse. Vita B. Johnson, Associate Professor of Law at Georgetown University, and former FBI Special Agent Michael German at the Brennan Center, who his work also documented the active collaboration and participation between law enforcement and white supremacist groups in 2017 during the Unite the Right rallies, and also throughout 2020 during the George Floyd racial justice uprising. So very challenging path to legislation. But again, and then there had been many loopholes kind of shielding these elements within law enforcement that again pose a huge public safety issue. And that's really the root of this for us, is that it's a public safety issue. There had been, we worked with the ACLU on language addressing First Amendment concerns, because again, that was another way that folks were able to kind of get around having accountability with regard to this in terms of free speech. And so naturally, we looked at numerous cases that established the responsibility of law enforcement as public servants to adhere to public safety standards. And so free speech is absolute, but when this free speech interferes with public safety or interferes with the duties of an officer as a public servant with regard to public safety, that is something that that has been ruled on in numerous court cases. From our perspective, police officers should have the highest standards of any public servant, as they have the ability to take a human life. So it was difficult to get traction on this legislation, but after the January 6th insurrection, I would say that because of the very visible aspect of law enforcement participating in the Capitol insurrection, that kind of shifted the public discourse, and I think it helped open a pathway to this legislation. And State Assembly Member Kalra it was the person that took that to the Assembly. I will say that throughout the process of the pathway to this legislation, we definitely were looking at RIPA data, looking at racial demographic data with regard to custody, deaths, use of force, etc. So that's kind of the background on it. Let's go to the next slide. So again, basically, Clear Act prohibits the employment of an officer found to have engaged in membership in a hate group, participated in any hate group activity, or advocated in any public expressions of hate. So goes on to define the public expression of hate, meaning any statement or expression to another person, including made in an online forum that is accessible, that explicitly advocates for, explicitly supports, or threatens to commit genocide or any hate crime, or that explicitly advocates for or supports any hate group. Hate crime, including, action by force or threat of force, et cetera, to willfully injure, intimidate, interfere with, oppress, or threaten any other person in the free exercise or enjoyment of a right or privilege secured by the Constitution. So the CLEAR Act covers all persons providing uniformed police services to members of the public. So without limitation, municipal police, county sheriffs, probation, custodial, and other officers under the California Department of Corrections, California Highway Patrol, University of California, Cal State University, Community College, also school resource officers, transit, park, port authority, etc. And so the statute requires the agency investigations of such alleged activity to, for one, upon application for employment as an officer or following a complaint alleging such activity. So one important thing I want to note is that our original intention with this bill was that it would require screening of existing law enforcement and leadership, as well as new candidates, as we're now faced with decades of this intentional infiltration by members of hate groups. Because, as I inferred in the beginning, some in law enforcement leadership have also either actively harbored these elements within their agencies, looked the other way, or been unaware. This still needs to be addressed with regard to current ranks, and would really require quite robust oversight. However, we hope that this bill and its full implementation will stop incoming extremists from continuing to join law enforcement ranks. I will say that after it passed, there was very little media attention on the bill. And our coalition wondered if it was being implemented and if agencies were aware of it, and just kind of how deeply folks were getting into it and if it was actually being adhered to. And so I think, well, let's go to the next slide. I think that's where post comes in as well. Just, again, with the rise of technology, this is really flourishing on social media as folks are, again, emboldened, really, really emboldened. These activities have also been, been like in the case of Antioch, linked to patterns of civil rights violations, excessive force, conspiracy, falsifying of records, etc. So basically, we feel that this law is very specific in that it is meant to identify and remove these basically domestic terror elements that are within law enforcement. It would be great if there was a federal law on this. It's not going to happen. And so it's up to us to address it. I hope that we can actually begin to kind of, I see the CLEAR Act and RIPA and like all of these laws are kind of coming together to hedge around this misconduct, and that there's no magic pill. There isn't one law that's going to take care of it all. We have to address this problem, though. And I do feel that this problem is likely getting worse, has the potential to get worse. So lastly, I'm kind of moving through this pretty quickly here because I wanna save time. Yes. Oh, you're muted. Oh, you're still muted, Jerry.
It looks like one of the slides is missing from this deck.
Okay.
So my apologies. It's about the proposed regulations that are in process right now. Can you cover that?
Thank you. Yeah, I was just going to talk about that. So basically, the California, again, it's a work in progress, right? So the California DOJ proposed regulations to AB 655 in January 2025, and then there's an addendum in June 2025 also that really seeks to clarify jurisdiction and ensure compatibility with post, and further define, the investigative and complaint process, including acceptance of anonymous complaints, which was, I'm very happy about that, because that was something that was really important to us, because again, for impacted communities, it's hard to go to the agency and complain to the agency that you feel is responsible for harboring these individuals, especially for communities that do not have oversight bodies, or do not have oversight bodies that are robust. The proposed amendments also allow the DOJ the option of investigating in the case of an agency being unable or unwilling. There is also a proposed amendment that is really worthy of discussion, which it revises the burden of proof for all forms of covered misconduct from preponderance of the evidence to clear and convincing evidence. So this is a matter of interest for me because it really diverges from the common standard for administrative discipline. The DOJ has stated that this revision more closely aligns the burden of proof standard with post, and that this is meant to avoid an officer being removed from appointment under the CLEAR Act, but not decertified by post. So from my perspective, an individual who is a member of a white supremacist group or a hate group, or is actively associating with one, should have no place in law enforcement, and this should not be something that should really be debatable. And so again, since there all of course is the disciplinary process and the legal process with regard to employment law and all of those implications of proving that person is actually engaging in these activities, and so that still needs to play out. Jerry, was there?
There's another question. There's another question. There was another question I wanted you to clarify,
Sure.
which is under the CLEAR Act. If there's a sustained finding of a violation of the CLEAR Act, it looks like there's another component of this law that's a little different than most things, most cases of sustained finding of misconduct, which is that it requires a police chief to terminate an officer if there's a sustained finding.
Correct.
So that's a very interesting thing that I think is worth highlighting.
Yeah, it is important. Again, making the distinction, we're not just talking about bias. We're not just talking about racial profiling, which are already significant enough problems to warrant this legislation. We're talking about active members of hate groups embedded within law enforcement and engaging in activities which constitute hate crimes and domestic terrorism. And so by that definition, there should be no discrepancy or leniency towards that type of behavior. And so with regard to the CLEAR Act, if an individual, if there are sustained findings, that person is done.
Thank you, Demetra, and thank you, Ed and John. There's just a couple of questions I want to throw out here for the group, and then we can take a look at what kind of questions are in our question and answer on Zoom. So these statutes seem to cover the waterfront in some ways in terms of approaches to the issue of officer bias. And, from implicit bias in RIPA and RJA to the explicit bias and hate crimes in the CLEAR Act. And so I'm wondering, in considering employee compliance with prohibitions against bias, do you think what matters is the state of mind of the officer, the actions of the officer, or do both matter?
I have a thought.
Okay, go, John.
I mean, I think they both matter, and that we don't want people to be working in law enforcement who are acting on bias, right? And so in that sense, for the individual officers, the state of mind of the officer is really important, right? But even so, I think the effects or the actions of officers are important on the collective level, because I think that sometimes here in California, when we talk about RIPA data in particular, there is some focus from people in law enforcement on their belief that the RIPA data doesn't necessarily show explicit bias by groups of officers. And I think regardless of whether it does or doesn't, the RIPA data clearly shows disproportionate impact of law enforcement work in California on people of color. There's just no question about that. There's no other way to read the data because it's such a dramatic disparity by race. And so I think that distinction is an important one for us to continue to talk about. That's not to lose sight of the fact that there's explicit bias out there, but we can and should also be using some of these tools to point out the ways in which, even if arguably maybe well-intentioned, the impact of a lot of these enforcement decisions are landing way heavier on certain parts of the community than others.
Yeah, if I can bring in another question that was from the chat function into this, a person made the point that many of these disparate impacts appear to come from explicit policies or strategies of the agency and its management that then get implemented in the field by individual officers. And the question was, what are we doing about that more systemic bias that may be in the way things are set up for enforcement rather than in the individual decisions of an officer? And how are we getting at that kind of bias? So I'm going to throw that back out to both of you, either or both questions. Demetra, Ed?
Ed, you're muted.
I'm not sure I understand the context of the question. Is it a suggestion that
let me give an example. Yeah, let me give an example. So I know, in the reviews I've done of different agencies, I have seen cases where an agency has an enforcement strategy of focusing on predominantly African-American neighborhood.
Sure.
And doing gang enforcement because there is a gang that is primarily located in this neighborhood. And it's very proactive enforcement where everyone's pulled over who's driving through a certain area. Those people all tend to be African-American drivers. And,
sure.
As you look at the cases, and review them on an individual basis, you can see that the drivers tend to be, even though different other people of different groups drive through them, they are not pulled over. So if that's the explicit policy and approach for enforcement, an individual officer may have no bias, but that's what they're required to do as part of that team. So
no, okay, I understand the context of the question. Yes, those types of, and I'll use a generalized term, a type of targeted, proactive enforcement, as we know, have been it's taken place systematically ever since I've been a cop and before I was a cop. I know certain segments of the community may not buy into it, but again, if there is a problem area, and unfortunately it has to be in an area that is predominantly Black or predominantly Hispanic or whatever, it's going to be politically driven to a large extent. I've been I hate to say this, but I've been involved with 10 different departments in my career, and a lot of these decisions are politically generated. The council person or the mayor says, "Hey, chief, you need to do something about this problem in this area," and so there's a massive police presence. You've got specialized enforcement units coming in. They're perceived as being overreactive, quote unquote, Gestapo-like, etc. It gets into a situation where it's like a damned if you do, damned if you don't. I wish I had a suggestion, a solution, but That's just one of those situations where there's just not going to be any winners. You're going to have different perspectives from both sides. What was the chief supposed to do? Say, nah, we're worried about the public backlash like last time. We're just not going to do that. That's not a solution.
And to add to that, in that situation where policy is being determined and then the specific officers are having to implement that policy. So RIPA is looking at the actions of the individual officers, right? But it also begs the question as far as how do we address the policy? And that's the systemic piece that you're talking about. Because how does that get, this is why I was for Clear Act that we were wanting screening for leadership as well.
Mhm.
Well,
Okay,
let me
go ahead,
one quick item. RIPA specifically, I think 2 years ago, and it's still their recommendation. RIPA has recommended to all law enforcement agencies management to monitor the social media activity of its officers. That's significant. That's always been a impediment to diving into these private social media lives of our officers. And so, that's becoming a little bit more, let's say, common, so to speak. The last thing I want to get is that phone call from the chief saying, Ed, could you do a deep audit on regarding social media regarding our department? That is it's offensive in a lot of ways. And I don't want to go around poking into other people's, albeit private conversations. So, a lot of cases, though, you can do, random audits and so forth. But in most cases, some of these officers, you don't have to deep dive. I mean, we get citizen complaints. We have citizens say, hey, have you seen this officer's Facebook post? And of course, we go, what Facebook post? And then the investigation is on. I get a lot of leads from those types of sources.
Tina, I'm having trouble pulling up the Q&A. Do we have any unanswered questions that we can get to?
Yes, I am happy to read them off. And thank you, John, for responding to a bunch of them. There were some really good questions that were posted earlier throughout the webinar. And John actually responded to quite a few of them. So if you haven't seen those already, those in the audience, please take a look at those. All right, so we do have some questions and we will get through as many as we can. Can you comment on any applications regarding ICE behaviors and assistance from California peace officers who may or may not be masked and agencies unknown?
Well,
maybe I can address that.
Go ahead. Yeah.
Again, not to self-advertise, but I did an interview on Cal Matters about a week ago on this. And there's a reason why there was opposition from law enforcement. For one thing, we do not hide our identities. I've never even run across a situation in 30 years of a complaint. Oh, this officer, is trying to hide who or she is, or trying to misidentify themselves. I've never had a complaint or had to deal with a complaint from anywhere on that. As a matter of fact, by law, we're required to display our name tag, our badge, visible ID, for obvious reasons. But these proposed laws regarding, coming from the legislature about criminalizing, quote unquote, masking, it just has no place for California law enforcement because we don't do that anyway. I've never seen an officer running, except for COVID, of course, running around, trying to, hide their faces. Those proposed laws simply are not going to apply to federal law enforcement officers. it's a effort in legal futility because California, we have we all know federal supremacy law is going to govern. No officer is no cop in California or DA is going to charge a federal ICE agent for masking. Bottom line, I wish that subject would just go away.
Yeah, Ed's points are sound, and also there's very little oversight, civilian oversight of any kind for ICE officers. There was some limited inspector general oversight, but that person has been removed from office. So, and they're ramping up very quickly with new hires, which gives me a great deal of concern because it's difficult to hire quickly and also hire well. So that's a challenging situation. Typically local law enforcement has provided assistance to ICE for criminal enforcement efforts. And when a crime has been committed, like an undocumented person has committed a murder in your jurisdiction, and if ICE is there and they're pursuing the person, you're going to assist in that. So it's a complicated situation. And sometimes the incident is unfolding quickly. So for local officers to make a call whether they're going to cooperate and support an enforcement effort in the moment is really something very difficult to expect of them, of the officer in the field. So I think we are going to continue to see some level of cooperation between local law enforcement and ICE. I think that's something that we shouldn't be surprised by. Now, you may have local policies and you can work on local policies for the context of that and hold people accountable based on those policies, but it would be a separate thing from the ICE actions.
And there is another question, and just FYI for everybody, I did put the link for the post-webinar discussion in the chat. Do not click that until you're ready to leave this webinar, because if you click it now, you will be booted off the webinar and taken to the discussion room. So don't click it until you're ready. There is a question about, Demetra, when you were presenting on the CLEAR Act, is it known how many officers have actually been discharged under this provision? And then there was a follow-up to that. National Decertification Index shows that as of, I think, January 2024, California Post had reported a total of 8 decertifications for all causes, not just CLEAR.
Yeah, so I had a question about that. I also have that question in terms of how many officers have been discharged under the CLEAR Act. I was wondering if there were any, because again, it's taking a long time for this to gain traction, even though it's been a law for a bit now. Ed, I was wondering if I might direct that to you in terms of Post, with your involvement in Post. I don't know, if there's data out on that yet. So I don't know the answer to that question.
Yeah, no, good question. I've asked if there's statistics on each of the categories.
Mm-hmm.
Again, as we all know, the SB2 process is still a work in progress, and I mean that respectfully. There are so many complaints. Last time I checked, this was a few months ago. Oddly enough, I was kind of surprised in terms of total complaints, and it wasn't broken down necessarily. I didn't dive that deeply, but there were I want to say 70,000 complaints total. And that is overwhelming. Post. I can't speak for Post, but you can imagine. And then, but oddly enough, and this is what surprised me, was that only 2,000 of those were from citizens. The rest were all internally generated. At least that's what I was advised. So departments, from what I understand, in dealing with departments, they're taking the cautious approach, saying, all right, if there's a question whether or not we should enter this complaint into the SB2 system, we're going to err on the side of caution and enter it. And but you can imagine the backlog, because the department also has to do an investigation and come to a conclusion of some sort. So it's really time consuming. But again, you know, as you know, the decertification process, is very time consuming. So there's so many cases in the pipeline, so to speak,
Right.
before we get any kind of say good statistical information as to the number of decertifications related directly to bias-based activity. It'll be a while.
If I might offer one thing about the CLEAR Act, whether, the question about the CLEAR Act violations. As we were saying when we were discussing this, the CLEAR Act itself is not well known even among law enforcement and civilian oversight. So consider how lesser known it is in the general public, who are the people that will be filing these complaints that are then investigated. So I think we're going to have a period of time where we're not going to see very many CLEAR Act complaints, because it has not received the sort of attention that would cause people to be more aware of it. Yeah.
No, that's true. My most recent presentation to chiefs, not one chief or sheriff even knew about the CLEAR Act. They said, what act? It kind of like Dimitra was mentioning, it kind of sailed under the radar, both media wise and also the lobbyists. Our lobbyists didn't know anything about this apparently, because looking at the bill tracking, and law enforcement lobbyists are pretty diligent about that. I could find nothing regarding their vote for a yes or no to recommend or not recommend voting for the CLEAR Act.
It is
And
quite
that was
the
kind of
elephant in the
surprising.
room.
I put into the Q's and A's for this webinar a link to the website that Post maintains to list all the officers they've decertified. So one can follow that. And it's pretty easy to Google it too, or one can look through everyone who's been decertified so far. And as Ed was pointing out, the backlog of all the cases they're still assessing for decertification is massive compared to the number of cases they've resolved. I don't see any in there where it's clear, or where it's obvious that a CLEAR Act violation was the root cause of the decertification. And I would imagine, venture a guess that it may be in all those cases that Post is looking at, they've put the CLEAR cases aside while these regulations that we discussed earlier about implementing CLEAR are still being figured out. That would be rational for them to sort of wait on those cases till they have the regulations done. I've not been told they're doing that, but I also am not shocked to see that there aren't any decertifications because of a CLEAR Act violation yet. I imagine those are all still in the queue.
Yeah, good point, because the fact that in my travels hardly any department even is aware of the CLEAR Act, they're not going to enter into SB2 violation of CLEAR Act. It's going to be under misconduct, bias, blah blah blah. So there's not going to be any direct formal linkage between the CLEAR Act and an SB2 complaint necessarily.
Possible.
So before we jump off, I just wanted to make one final point, which is that there are support materials for this webinar that will go out in an email following. So thank you, everyone. Very interesting. And we will be going to the discussion room.
Thank you.
And in the discussion room, you can speak directly with everybody, audience members with speakers and vice versa. Jerry, Dimitra, John, Ed, thank you so much for sharing your time with us this evening, and your expertise and for all that you're doing in this area. And I will see you all in the discussion room. I'm going to hang back for a minute or so just to ensure that everybody who wants this link has it. And for the panelists, I also emailed this link for you just in case anything goes awry after you click it. So it's in your email box as well. Thank you all. And thank you everyone who attended for joining us today.
Thank you.
Thank you.
Thank you.